I almost forgot the live stream this morning. My bad. So this is Mr. Vicker and Mr. Cole. Comes Mr. Polk. Good morning, Mr. Polk.
Morning, Judge. How are you?
Good, you here on Smith?
I am.
Okay. Smith.
Calling case number 2205-789301, People State of Michigan versus Alexander Smith. Defendant is charged in count 1, homicide murder, first degree premeditated. Count 2, assault with intent to murder. Count 3, reckless driving causing death. Count 4, failure to stop a single accident when at fault resulting in death. Count 5, reckless driving causing serious impairment of body function. Count 6, failure to stop at scene of accident resulting in serious impairment or death. Defendant has a commission of felony with a mobile for advisory.
Appearances for the record, please.
Good morning, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P 85288.
Your Honor, may it please this honorable court, Larry Polk on behalf of Mr. Alexander Smith. I'm asking the court to waive his presence. I believe that he is still in the forensic center. So based upon that, I'm asking that his presence be waived.
For to waive the defendant's presence. I am in receipt of a report from the Forensic Center dated July 5th, 2023. And they are of the opinion that Mr. Smith still remains incompetent to stand trial.
I am in receipt of that report as well, Judge.
As am I, Your Honor.
Stipulating to its findings.
Yes, sir.
The people are as well for this one. I believe the next report from the Forensic Center would come on October 3rd of 2023.
What do you mean?
So the Forensic Center's report indicates that he is still incompetent, but they are attempting to restore competency. They're required to provide updates every 90 days. The next report would be due on October 3rd by my calculations.
Oh, okay. I see what you're saying. So the report will be done or needs to be completed by October 3rd. We'll set the hearing for October, I think I can do October 13th.
I'm sorry, did you say October 13th, Judge?
Yes, October 13th at 8:30.
All right, very good. Thank you, Judge.
That works for the people. Thank you, Judge.
You and your staff have a great day.
Thank you, you too.
All right.
Have a good day, everybody.
You too.
This one.
Your Honor, this is Brian Johnson. I'm waiting for Mr. Bickert, but I have a 10 o'clock in front of you, so I'm gonna go ahead and head over right now.
Okay, sounds good.
And then hopefully he'll log in while we're doing our exam.
Okay.
Okay, thank you.
So we're,
Yes, sir, Mr. Yes, sir, Mr. Clemens.
Hey, Judge, I'm just letting you know I'm coming from Frank Murphy. I'm maybe 5 minutes late.
Okay, we'll be here.
Thank you.
All right.
Mr. Rick, show up now.
Not yet.
Yes. Brian Johnson. Yes. No, it's gonna be Adam Clemens. Yes. Johnson. Yeah, well, I'll say it right. Adam Clemens.
Just me. Yeah. Just Right.
Bickert is here.
Oh, good.
So glad you could join us, Mr. Bickert.
Please.
Mr. Bickert?
Can you hear me, Your Honor?
Yes, sir, I can.
I'm sorry, Your Honor. I apologize to the court, Mr. Johnson. It's been a string of events this morning, and I greatly apologize.
All right, are ready on Goodwin?
Yes, sir.
Calling case number 2305-668201, people of the state of Michigan versus Darshante Goodwin. Defendant is charged in count 1, homicide, murder, second degree. Defendant has a habitual offender, second offense notice.
Appearances for the record, please.
Good morning, Your Honor. To your staff, this is Brian Johnson for the people. 841.
May it please the court, Your Honor, Tyrone Baird appearing on behalf of Mr. Darshante Goodwin, P number 62647. Good morning.
And what's your pleasure, Mr. Bickert?
Well, Your Honor, I would be prepared to stipulate to the findings of the report.
Mr. Johnson?
People would stipulate, Your Honor, that he's incompetent to stand trial, but likely to attain competence if provided the course of treatment.
All right. Before we make the finding that the defendant is not yet competent to stand trial, we'll refer him for treatment, and we will review the matter again on October 13th, 2023 at 8:30.
Your Honor, I'm sorry, I couldn't hear the time. I apologize.
8:30.
Okay. Thank you very much, Your Honor. My apologies again, Mr. Johnson, to the court.
All right, so have a good day.
Thank you. You too.
Mr. Clemens said that he was on his way to Frank Murphy. How's Mr. Perkins today? Doing well, how are you? Hanging in there. Not too much, which is a good thing, because I got to prepare for this evening. I teach at Wayne State. They have a midterm today. Constitutional criminal procedure. Final criminal. I'm back. They went to the morgue last week. Did Wayne come? We ran into a little bit of a snag, though, because they were doing an autopsy of a 2-year-old. They didn't let us in there to see that. So we had to wait till they finished out. 2-year-old. Constitutional criminal procedure. That's not the first report, that's the second. Yes, or second of the class. Wow. Well, I started off at Q4 back in around 2009, something like that. And I did Paris State, a couple years ago. Wayne State, I started last year. At law school this fall, UAB's law school. We'll go back home. All right. I'm looking forward to that. It's a criminal procedure that is post adjudication. Is it? That's really interesting. Yes. Yes.
Best tag team, you mean to say?
No.
No, all right.
I'm just.
Just a minute. Like to have the best. I learned from the best. What's new? Merci. Yes. He's the officer in charge. Yes. I normally do. Yeah, all right. You'll get it.
Ready, Judge?
Yes, sir.
On the set.
Ready?
Yes, Your Honor.
Marcus L. Freeman. Calling case 2357261, people of the state of Michigan versus Marcus L. Freeman. Defendant is charged in count 1 homicide, murder, first degree premeditated. Count 2 and 3 assault, intent to murder. Count 4 weapons, firearm, discharge from vehicle. Count 5 through 8 felony firearm. Here's the order.
Good morning, Your Honor, to your staff, Brian Johnson for the people, P84143.
May it please the court, Your Honor, my name is Adam Clements, P number 77233, appearing on behalf of the defendant. Sir, state your name for the record, please.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Ready.
How many witnesses will be?
I have 6 to 7 witnesses. They'll be short.
Okay, do you have any preliminary matters you'd like?
I do, Your Honor. I have 3 preliminary matters. The first 2, people filed 2 motions to allow witnesses to testify electronically. One is for a woman named Velma Tutt, and one is for a woman named Stephanie Sparks. They were both evidence technicians at the time. This occurred back in 2004. Ms. Tutt had neck surgery and relayed to me that it would be a hardship for her to appear in person. And Ms. Sparks lives in California. And under 766.11a, it says on motion of either party, the magistrate shall permit the testimony of any witness except the complaining witness, an alleged eyewitness, or a law enforcement officer to whom the defendant is alleged to have made a statement to be conducted by means of telephonic, voice, or video conferencing. Both are evidence technicians. Neither of them fall under the category of alleged eyewitness, complaining witness, or law enforcement officer to whom the defendant is alleged to have made a statement. So people would seek to have both of them appear via Zoom. Hopefully they're on the Zoom.
Oh, I see.
Okay, Velma.
Who's the other?
Stephanie Sparks.
I don't see Stephanie Sparks.
Okay,
I have a Samsung phone here. I'm not sure if that's her.
that might be, I don't know.
Judge, the only thing that I'd say is that the entire basis of this case is forensically based. they're the most important witnesses that the government has to offer, and they're not. So I'll make that statement and I'll let the court, it's a DNA case.
We should acknowledge that the statute says shall.
Correct. It's not discretionary.
So
Thank you, Your Honor. And then the next would be under 766.11B.
evidence check here. Whoever this guy is.
That's not my evidence.
I can't hear.
Good morning, on this iPhone. Okay. Anything else?
People have a preliminary CJIS amid People's Exhibit 1, which is the postmortem report under 766.11. Exhibit 1, published in the report, relevant portions.
Any objections?
No.
Admitted?
This is a preliminary exam or a medical report. ME case number 04-05974. Date pronounced dead, June 28th, 2024. Performed on an Antonio Hodges on June 29th, 2004 by Boguslav Pitek. That's BOGUSLAWPIETAK and D, Wayne County Medical Examiner's Office. It is his summary and opinion that 28-year-old Antonio Hodges died of multiple gunshot wounds. Postmortem examination revealed 5 gunshot wounds present. They are arbitrarily numbered and are not meant to indicate sequence of firing. And then it goes on to list, talk about the 1, 2, 3, 4, 5 gunshot wounds and where they entered. And then he also said additionally, there are several abrasions on the top of the head and a bullet jacket is recovered and retained from the clothing. The manner of death is homicide. Therefore, the cause of death is multiple gunshot wounds and the manner of death is homicide.
That's an understanding for the preliminary examination purposes. First and foremost, Your Honor, procedurally, I would place my appearance on the record. May it please this honorable court. My name is Todd Wilson Perkins, P 55623. I am co-counsel on behalf of Mr. Freeman with Mr. Clemens, who just stepped away momentarily.
Okay. Anything else, Mr. Johnson?
Would the court like to see the examination?
Yes, please. Yes, sir.
People call their first witness Christopher Wilson.
Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so be God? Yes, sir. Thank you, sir. Please have a seat and put this box right next to me. Keep your voice up nice and loud and speak into that microphone that's going to continue left, okay? Thank you, Jimmy. You ready?
Thank you, Your Honor. Can you hear me, sir?
Yes, sir.
Okay. Can you state and spell your name for the record?
Christopher Wilson, CHRISTOPHER
How old are you, sir?
48.
Okay. And I'm going to take you back to June 28th, 2004. Do you remember that day?
Yes, sir.
Okay. And where were you working at that time?
I was working at the Hard Rock Cafe and Litchfield Landscape.
Okay. And around 4 after work sometime, did you find yourself at 15491 Tuller Street?
Yes, sir.
And what city is that in?
Detroit.
What county is that in?
Wayne.
Okay. And on Tuller Street, what is that? What is there?
Houses.
Is it a house? Okay. And whose house was it?
I was at my cousin's friend's house across the street from my auntie house.
Okay. Do you remember the cousin's friend's name?
No, I don't.
Okay. Did you know a person named Antonio Hodges?
Yes.
What, did you know him by another name?
Yes.
What?
Who?
Who? Okay. How long had you known Mr. Hodges?
I know him for a little while, through my cousin.
Okay. And who all was there with you?
It was me, who, my cousin, John, and, two other guys.
Okay. And where were you guys situated within the house?
We were sitting on the front porch,
Okay. And what were you guys doing?
sitting there having a drink.
Okay. And while you were sitting there having a drink, how long were you, did something happen that brings us here today?
Yeah,
Okay, what happened?
guys pulled up and shot the porch up.
Okay, we'll talk about that in a second. How long were you sitting there having a drink before you guys pulled up?
Not too long.
Okay. By not too long, you mean a few minutes?
Probably less than, half an hour.
Okay. And when you say, what was it? Was it a sunny day?
Yeah,
Okay. And it was during the daytime?
yes, sir.
And when somebody, before the house was, before you say somebody shot at the house, what was the first thing you saw?
I saw, we were sitting there drinking, I saw a guy, I saw some guys pull up in the car,
What kind of car was it?
a black Stratus.
Your Honor, if I may. May I ask that, that Ms. Velma be placed in the waiting room?
Oh, yeah.
Okay, Ms. Sparks is here as well. Ladies, I'm gonna put both of you in the waiting room, okay? I'm gonna put you in the waiting room, Ms. Sparks.
I'm sorry, I didn't hear you.
I said, I'm gonna put you in the waiting room until we're ready for you, okay?
Okay, no problem.
You said you saw a car. Do you recall what kind of car it was?
Black Stratus.
Black Dodge Stratus, okay. And it was a four-door?
Yes, sir.
Okay. And from what direction? From what direction did the car go?
It's come from Midland, going towards the lodge.
Okay, is that, as you're sitting on the porch, is that coming from left to right or right to left?
Sitting on the porch is coming from left to right.
Okay, so did it drive down the street slowly or quick?
We go down the street slowly,
Okay,
and go right up to the curb.
right up to the curb, okay. And did you see anyone in the vehicle?
Yes, I seen two gentlemen in the front seat.
Did you see anybody in the back seat?
I did, it happened so fast, I couldn't look at that.
Okay, did you recognize any of the men in the front seat?
I seen a light skinned gentleman that was driving with a bald fade, and a dark skinned gentleman on the passenger seat that had a 9mm.
Okay, and did they stop at the curb?
Yes, they did.
Okay, and what happened when they stopped at the curb?
When they stopped at the curb, they jumped on the passenger side, pulled out a 9 and started shooting.
Okay, and what, did anybody else shoot?
I was trying to get up and run, I didn't see who else was shooting.
Okay, how many shots did you see? Or did you?
It was just all so fast, I didn't see how many shots.
Okay, and were either of them wearing masks that you recall?
No, dark skinned fellow with the long hair on the passenger side and a hoodie on.
Okay, and do you know if the driver had a gun or not?
It was happening so fast, I didn't see it yet.
Gotcha. Okay. And you said one of them, you said that the gun that you saw was a 9mm?
Yes.
How far away were you?
I was sitting on the porch, from the porch to like where that bench is at.
Okay, so you're probably, I'm just estimating, a standard porch to sidewalk to curb length from a house,
Yes.
25, 30 feet?
Yes.
Okay. And how many shots did you hear?
It went off. I also heard I got shot over 15 times.
So, okay, so you heard shots. What did you do when you heard the shots?
I tried to get up and run.
Okay, and what happened when you tried to get up and run?
Yeah, I tried to get up and run. I fell, and I got hit more times, and the guy next to me got hit in the leg. And flipped him in the air, and I tried to push him between the cars, away from the gunshots.
Right.
And laid there and tried to fall up as small as I could. I finally pushed him as I got hit in my back and both my butt cheeks and my thigh. I finally jumped over him and pushed him between the cars. And they rode beside the car.
Okay. And, how many times were you hit?
They stopped counting 15.
Okay. So you were hit at least 15 times?
Yes.
Okay. And you said something about an AK. What makes you say that you got hit with an AK?
That's what the doctor said.
And what kind of injuries did you receive? Did you get?
Multiple injuries in my legs, my ankle, my back, both butt cheeks, my front thigh. A lot.
Did you go to the hospital?
Yes.
How long were you in the hospital?
2 weeks. And I've had multiple surgeries.
And are you still dealing with this today?
Yes, sir.
If you know, after you were shot, did you see where the car went? What happened to the car?
It went towards the freeway and turned down the street. They went around the corner and shot somebody else.
Objection, yes, sir. Or objection, Mr. Foundation.
Well, how do you know that it went around the corner? Jackson?
Because the guy that came back, they chased them. So
Okay, so it's all from what you heard. You didn't see it yourself. So what did you actually see?
I seen the guy go down the street and turn the corner.
Okay. And did you recognize any of the guys in the car?
Objection, asked and answered. Said no. He said no twice.
No, I asked him the description of the people in the car. I didn't ask him if he recognized them.
Okay. Go ahead.
Did you recognize anybody in the car?
No.
No. Only if you know. Do you know if Mr. Hodges had any beef with anybody in the neighborhood?
What I heard.
Okay, just from what you heard. I have no further questions for this witness.
Yes, very briefly. Good morning, sir. Sir, my name is Adam Clements. I'm going to ask you some questions on behalf of the defendant in this case. If I speak too fast or I ask you a question you don't understand, just try to let me know and I'll try to ask you a better question, okay?
Yeah.
Okay. Now, you had indicated that you were on the porch at a home on Teller Street on this particular day where you were shot, correct?
Yes, sir.
Okay. How many times have you talked with police between 2004 and now?
4.
And are the majority of the conversations more recently, or did you have a lot of conversations in 2004? Okay. So a couple conversations 19 years ago and then some new conversations now. Is that correct?
Yes, sir.
Okay. Would you say that your memory regarding the incident was better in 2004, or do you think it's better now?
Sorry.
Okay. So, do you recall specifically telling Officer Christine Robinson that there were approximately 3 men in the car that were shooting and that they all had on black ski masks?
No, I didn't say it.
Okay. Do you recall speaking with Officer Robinson at the hospital? Do you recall speaking to a female police officer at the hospital?
No.
Okay. Do you remember what you told her?
I don't want to speak to a female officer.
I'm gonna ask you to take a look at this document and see if that refreshes your recollection as to what you told her back in 2004. Okay? Yeah, approach that. Okay. So read this to yourself and then look up that again. Finish. You'd agree that when you had an opportunity to speak with the police at the hospital, you didn't tell them anything about a 9mm, correct?
I don't recall.
Okay. When you had an opportunity to speak with the police at the hospital, you didn't tell them anything about seeing a light-skinned guy, correct?
I don't know what you're saying.
And when you had an opportunity to speak with the police specifically, you didn't say anything about an individual with long hair that had a hoodie, correct?
I talked when I got out of the hospital.
No, I'm talking about at the hospital.
At the hospital, I was in pain, getting shot with 15 times.
I appreciate that. Did you tell the officers that you're in a position that you can't talk right now? Did you ever say that?
I was, like I said, again, I was in pain and asking questions and I'll be shot with it.
I appreciate that. My question to you was, while you were in the hospital, did you tell the officers that you're not in a position to communicate with them? You tried to give them information, right?
I tried to, yes, I did.
Okay, you tried to cooperate with them, right?
Yes, I did.
And you tried to give them the information that you, as you recalled it, as best you could at that particular time.
Yes, I
Fair?
did.
Okay. And isn't it true that on that particular date, when you spoke to them, you said that these were 3 individuals that just had on black ski masks at that time, correct?
I don't report it.
Fair enough. Thank you. Nothing further, Judge.
Can you redirect?
Yeah. When you saw the car, did you remember anything about the license plate? You saw a license plate?
Yes.
That's outside the scope, Judge. I didn't ask anything about it.
It is.
Yeah, I have some leeway just to ask him a question that I wanted to ask him, right? Do you remember anything about license plate?
Yes, sir.
What was it? Like?
And the paper plate was back with.
Okay, thank you.
Anything else, Mr. Clemens?
No.
Thank you, sir. You may step.
People call Officer Flemish.
So please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat with this box.
Thank you, Your Honor. Officer, can you state and spell your name for the record, please?
Christopher, last name McLeodich,
How do you spell your last name?
MUKLEWIC, Charlie Z.
Okay, and where do you work?
City of Grosse Pointe Park, Public Safety,
And where were you working back on June 28, 2004?
Detroit Police Department, 13th precinct,
And how long did you work at Detroit Police Department?
15 years total.
And on June 28, 2004, do you recall responding to a hospital?
Correct, Henry Ford Hospital in Boulder.
Okay, and do you recall who you talked to?
No, I don't.
Okay, do you recall any kind of conversation that you had with anybody at the hospital?
I recall being there. I remember that it was a shots fired shooting report, GSW, I'm sorry.
Okay.
And the victim was did suffer a shot with the right knee.
So do you remember specifically that?
Yes.
Okay. May I approach the witness, Your Honor?
Ma'am?
Showing you your report from that day. Is that your report?
Yes, it is.
Is that your handwriting?
Yes, it is.
Did you write that close in time to the time you met with that person
Yes, I did.
at the hospital?
Yes.
Okay. In reading that report, have you read that report recently?
Yes, I did.
Okay. Did it refresh your recollection as to what conversation you had with this person? Or what?
It refreshed my recollection to going to the hospital with my partner on the victim being shot.
Okay, but you don't recall anything else about that? Do you recall anything else about the?
Yeah,
action?
that according to the victim, when I took the report, according to the victim, that he was on the west side and was transported to the hospital.
Do you recall anything else about specifics about the report?
No, I don't.
Okay. And you would agree that it was written close in time to the time you spoke to this person?
Yes, sir.
And do you commemorate conversations with people in reports?
I'm sorry.
Do you, when you talk to people, do you, in your official capacity, of course, do you write down what they tell you in reports?
Yes.
For further, so you can go back and refresh your recollection, right?
Absolutely.
But you're saying at this point, you don't recall the exact conversation you had with this person?
No, I don't.
Okay. And, Your Honor, at this point, the people would seek under 803.5 recorded recollection to read into the record the statement that was adopted by the witness at the time. The defendant or the witness now has an insufficient recollection to testify fully and accurately, but it has been shown that it was made or adopted by the witness when the matter was fresh in the witness's memory. I understand that I can only read it into the record, but it may not itself be received as an exhibit unless offered by network.
The objection would be that the police report is hearsay.
It's not hearsay, it's written by him. He can testify to what.
When out of court statement offered for the truth of the matter, so
Yeah, but he's on the stand, he can testify to what he wrote at the time. It's a hearsay exception as a recorded recollection, because he doesn't recall the actual statement that he made. And I have case law that can testify to exactly to police reports.
But what he's attempting to do is integrate statements from other individuals that are incorporated into the report, which are also hearsay, which is why police reports are not admissible and they are hearsay. It would be different if it was just a memorandum about his own statement and his own observations. Instead, the prosecution seeks to indirectly admit conversations, which is exactly the hallmark of the hearsay rule.
But the statement that I'm trying to get out is a statement that he had with the defendant, who's a party opponent. So it would still not be hearsay. The statement from the defendant would not be a party opponent. The 8035 exception comes in that he does not recall the statement that he made, and that he would, and that I would read into the record as evidence what that statement was at the time that he took it, close in time.
So if we were talking about a witness, not a defendant, not a party opponent, then it would be hearsay. But given that this is the alleged defendant's statement,
He did identify that.
But it's going to be, it's on the,
He's relying on the document to do it, Judge. It would be different if the officer came in and said, yeah, I've seen him before, I recall him, I remember him. It's the defendant that gave me that information. He's relying on the document to say that the defendant gave me the information, which makes it different. The officer testified he doesn't remember anything.
how are you going to establish that this is the defendant's statement?
because
They gave a statement.
the statement itself is given from a guy named Marcus Freeman.
That doesn't.
That guy's still waiting on admissibility at this point.
No, it doesn't, Judge. He had to, in order to utilize the party opponent exception, the person who's saying the party opponent told me this has to be able to identify the party opponent and say, this is who told me this. Otherwise, he's relying, the officer already testified, he's relying specifically on the document in order to get that information.
Yeah, I can talk about my handy Michigan courtroom evidence annotated about how police reports are able to be read into the record when the witness does not have sufficient recollection. And I think it gets to weight on admissibility regarding whether this statement was made by the defendant himself or by somebody else named Marcus Freeman that was shot close in time to the shooting. So
I'm inclined to agree with the assistant prosecuting attorney that would be more so as to what weight I should attribute the alleged statement that was supposed to be given by the defendant. I'm waiting to see if the people are able to show anything to support this is in fact the defendant having medical records and the like in case of the defendant or in the description of the person being treated. May proceed. The objection is noted.
do you recall the race of the person being spoken?
No,
Okay. Do you recall if it was a male or a female?
man,
Do you recall seeing any injuries on them?
that's a right gunshot wound right there.
You remember seeing that specifically?
Yes,
And it was at Henry Ford Hospital?
right.
Okay. How far away is Henry Ford Hospital from Teller Street, if you recall?
From what street?
Tuller?
Not familiar with their television.
Okay. Are you familiar with where Davidson is?
Yes.
How far away is Henry Ford Hospital from Davidson?
Oh, probably close to 7 or 8 miles.
My question, Witness Shriner?
Yeah.
So, Your Honor, what is commemorated here in this report is Officer McClevich wrote at the time that Marcus Freeman lived at 15345 Alden, at date of birth of 3/13/1979, and he was 25 at the time, black male. And he says complainant, this was a police report to 2799 West Grand Boulevard, FA report. What does FA stand for?
Felonious assault.
Felonious assault. Complainant states he was walking westbound on Davidson when he heard several shots from unknown direction. Complainant ran into a store at an above location and observed he was shot to the right hand. Complainant TRP transported to HFH, Henry Ford Hospital, by an unknown person at the scene. Temporary serious for Dr. Highland, gives the chart number. Observations, stated injury to complainant's right hand, signed by Christopher McLeod. I have no further questions for this witness.
Cross-examine.
Good morning, Officer McClellan.
Morning, sir.
Officer McClellan, you indicated that you responded to Henry Ford Hospital, is that correct?
Correct.
The individual that you talked to, was it your understanding that he was a suspect or that he was an actual victim?
At the time, there was a victim.
Okay. Did you offer that individual an opportunity to complete a written statement?
No, I did not.
At that time, had you been trained or had experience on how to conduct written statements?
That was not a matter of procedure for the department at that time.
So that would have been something that you would do, is that correct?
It was not something I would do.
Okay. You were under the impression that the individual that you spoke to had been shot, is that correct?
Correct.
You know what happened with the bullet?
No,
Who would I speak to about what happened with the bullet in relationship to that shooting?
I just wouldn't know.
The report that you offered at this particular time, did you detail whether or not there were any witnesses that were there with the individual that you spoke to who indicated to you that he was shot?
No, I did not.
Do you know who transported the individual to the hospital?
No, we did not.
Do you know yourself personally whether or not someone actually shot this individual or if the wound was self-inflicted?
No, I did not.
Okay. Now, you indicated that it was explained to you that this individual had run into a grocery store or a market. Is that what was explained to you?
Correct.
Okay. Where is that market located?
I do not. I'm sorry. Sorry, I spoke. Davison.
Okay. Did you go
As
to,
indicated by the.
did you go to that market?
No, I did not.
What was this individual wearing on the date and time that you spoke to him?
I don't recall.
If the individual was shirtless, is that something that you would remember?
No.
Okay. If the individual wasn't, let me ask you this. Would you at least be able to tell the court that the individual was wearing some type of clothing?
I presume so, yes.
Okay. And the individual was nude or in underwear only? That's something that you would probably highlight in your report. Is that correct?
Correct.
Okay. Because that could tend to be something else that could be relative to the investigation. Is that fair to say?
It could be.
Okay. Did you notate any other injuries on this individual?
No, I didn't.
Okay. Did you yourself see any shell casings in close proximity to this individual when you spoke to him?
No, I didn't.
Did you get any inclination at the time that you spoke to this individual that they themselves had fired a weapon?
No, I didn't.
Thank you. Nothing further.
Anything else? Thank you, sir. You may start.
Thank you, Your Honor.
People will call Sergeant Eugene Fitzhugh. Sergeant Fitzhugh. We'll start.
Good morning, sir. Please step forward, give your name and spelling to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat. Please respond. Thanks. Yes, sir. Maybe when you're ready.
Florida.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you spell your name for the record, please?
Certainly. My first name is Eugene. It's Eugene. Last name is Fitzhugh. It's Fitc like Zebra, Hugh.
And where do you work, sir?
City truck dispatch.
And how long have you worked?
34 years.
Were you working back on June 28th, 2004?
Yes.
Okay. And I'm gonna take you back to around 5:25 that day. Did you find yourself at 15491 Teller?
I did.
And is that in Detroit?
It is.
Okay. And do you recall what was there?
It was a scene, in front of that address, there was two cars parked in the driveway on the north side of the house. There was a body on the front porch.
Okay. And do you recall the scene?
It's been a long time.
Okay. Did you refresh with the report? You had the report?
I have it back. Yes.
Okay, sure. So you said there was a body at the, do you remember that specifically?
It's hard, favorite, I could say.
Okay. And was it a house? Okay. And do you recall if you retrieved anything from the victim?
There were some live rounds in his pocket. I had to refer my report to be more specific than that.
Do you have your report with you?
I did.
Okay, if you want to refer to your report, look up when you're finished. It's on page 2.
That's good. Nine rounds, 5 were special less than 30, and the others were Winchester.
You found those in the pants pocket?
Yes,
Do you recall if you retrieved any shell casings from the scene?
I did. They were in the driveway area of the house.
Do you recall?
Next to the house.
Do you recall what kind they were?
Yeah.
Okay, refer to your report and then let me know if it refreshes your recollection.
I got 6 FC manual and 16 7.62.
Okay, and do you recall photographing them? Did you photograph them? Did you collect them?
I did.
Okay. And are 9mm casings and 7.62, are those from different caliber weapons? Okay. Do you know what kind of weapon a 7.62 would be associated with?
7.62 is typically a semi-automatic rifle.
What about 9mm?
And it could be a semi-automatic pistol.
Okay. And did you place these into evidence?
I did.
Okay. I have no further questions for this witness.
Cross-examine.
Indicated that you had an opportunity to examine the scene on that particular day, is that correct? You indicated that you had an opportunity to observe where the deceased was on that particular day on Teller Street?
Yes.
And then you recovered some bullets from his pockets, is that correct? Those bullets were ready to be fired if they were placed into a fire, is that correct?
If they were live rounds, so yes, if they were interrupted in the weapon, they could be fired.
These weren't spent shell casings or fired bullets, right?
They were live.
All right. And you could see that there were fatal wounds that this individual had suffered, is that correct?
Yes, one for sure, yeah, one. Up there, just a little turn, and one across the eye.
Did you see any fired bullets from that would come from a 7.62 shell casing around that individual? Okay. Do you know what happened to the bullets that were taken from this individual's body? Okay. And you got some significant experience collecting evidence, is that correct? So you'd agree that when you collect evidence, the normal process is to take the evidence, bag it, and itemize it with an evidence tag, is that correct?
Basically, yes.
And then subsequent to that, after you place that item on evidence, you then take it to the evidence lockup at headquarters to ensure that it's maintained, that it maintains its evidentiary integrity. Is that correct? That's correct. How many times have you taken bullets or live rounds or things of that nature that had evidentiary value? How many times in your career have you taken that evidence to your house? Objection, relevance. Seriously? He's talking about what he did within his time. I don't know what he did in evidence to his house.
Where do we get evidence taken to the house?
Because it happened in this case. So what I want to establish for the record is I want Mr. Fitzhugh to establish the proper way that evidence is supposed to be tabulated and whether or not it's proper pursuant to policy.
You can ask that question.
Okay. Is it proper pursuant to policy for officers to take evidence that's tagged with an evidence tag number relevant to a homicide? Is it proper for officers to take it to their house?
In the sequential way that you provided that information, no.
Okay. Is it proper for officers to abandon that evidence in a house and leave the house unattended? Sure. Say, for example, that you were to you recover fire bullets in this particular case, correct? Is that a yes? Say, for example, you were to place those bullets on evidence and then take them to a property that you have where you spend some time at and then leave it there and never come back to it. Would that be proper pursuant to policy?
Well, first of all, that shouldn't happen. No, that's not proper.
And in fact, it would seek to destroy the evidentiary integrity that the entire process is designed to maintain. Is that fair to say?
That would be fair to say.
Thank you. Nothing further.
Can you redirect?
In this case, the physical evidence, what did you do with it?
When I collect evidence at a scene, it's packaged, temporarily packaged. When I go back to my work location, I indicate this envelope usually sometimes a band or whatever is appropriate to be able to do it. It's indicated on that bag or envelope or container what specifically the evidence is. Usually I go in there where I got it from. It's put into the computer. The computer assigns the property tag number, prints out a tag, a label, and then we attach it to the property. Okay. Then it goes to property.
Okay. Do you recall, did you do that in this case? Did you ever take it to your house?
No.
Okay. No further questions.
Anything else? Thank you, sir. You may step up.
People call Velma Tech, who's on Zoom.
All right. Ma'am, please tell us your name and spell it. Unmute yourself. Tell us your name and spell it for us, please. Tell us your name and spell it for us, please.
Velma M. Tutt. VELMATUTT.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. Haven't seen you in a while, Ms. Tutt. Go ahead, Mr. Johnson.
Thank you, Your Honor. Ms. Tutt, can you hear me?
Yes.
Okay. I want you already spelled your name. Are you currently working?
No, I'm retired right now.
Okay, good. Where were you working back in June of 2004?
The Detroit Police Department.
And how long did you work there?
I was with the Detroit Police Department for 23 years.
Okay. And back in 2004, what was your role? What were you doing?
I was working as an evidence technician.
Okay. Did you know Mr. Eugene Fitzhugh?
Yes.
And did you guys work together?
We have, yes.
Okay. On June 28, 2004, do you recall responding to 2645 West Davison?
Yes.
What city is that in?
Pardon me?
What city?
Detroit.
Okay. And do you recall what was there?
Do I recall who was there?
What was there? What's at that location?
Oh, I was called there in regards to, it was a vehicle, if I can remember, it was a vehicle that was there that was supposed to have been involved in a shooting.
Okay. What, do you recall what's at that location?
That
If you need
area.
I say, do you have your report in front of you?
Yeah.
Okay, if you need to refresh your recollection, just let me know.
Okay, it was the Atlas Food Market.
Okay. And so it was a food market. And do you recall what you saw when you got there?
I can't understand what you said.
Do you recall what you saw when you got there?
Yes.
What did you see?
At the at the west end of the parking lot, there was a vehicle that had ran into a stop sign, a pole that was at that end.
Do you recall what kind of vehicle that was?
Yeah, it was a
What
2000.
kind?
It was a 2004 Ford Concord, black in color, 4-door.
Okay. And did you examine the car?
Did I what?
Did you examine the car?
Yes, I did.
Did you find anything inside the car?
Yes, I did.
What did you find?
On the front seat of that car, there was shattered glass and spent casing. On the floor, front of the rear passenger seat was a clip. And on the floor behind the driver's seat was a brick and suspected blood and a spent casing.
What kind of spent, do you recall what caliber spent casings you found?
I have to look at my
If it'll refresh, yeah, if it'll refresh your recollection, take a look and then look up when you're done.
And I'm just only, as it appears that Ms. Tutt is doing some reading from the report, I just asked that the recollection be refreshed in the testimony. I know that this is what happens when you ask people to testify about something 19 years ago, but still none of this.
All right. So, Ms. Tutt, if you have to refer to your report to refresh your recollection, let us know. Until then, we want you to testify from your memory as best as you can.
Oh.
If you need to refer to your report, let us know, and then you may do so. Okay.
Okay. On the floor behind the driver's seat was a spent casing round, a 7.62 by 39.
And how many spent casings did you find?
A total of, I think it's 14.
Okay. And you said you found a magazine or you found a clip?
Yeah.
What is a clip?
A clip is it goes inside the weapon that was there at the scene. I'm not sure exactly what kind it was. I don't remember if it was like a banana clip or just a regular clip that goes inside the gun.
Okay.
Judge, I'm going to object to that testimony. The witness just indicated that the magazine that was recovered goes inside the firearm that was at the scene. That was the testimony that was given. I heard no testimony about the firearm being at the scene.
You say it goes inside a firearm?
No, the firearm that was at the scene. And even if she did say a firearm that was at the scene, that's still improper because she wouldn't know that.
At what scene are we talking about?
Either scene, Judge. How would
If she arrived at the scene that she responded to and she found the firearm, what's wrong with that testimony?
and if Judge, if she indicated that she found a firearm, I wouldn't object. The testimony is that she found a magazine only. So to say that I found a magazine and it goes to a firearm that was at the scene, which was the testimony, is improper.
Okay, let me get some clarification. Ms. Tut, did you find or observe a firearm at the scene?
No, I didn't.
So you indicated that this clip went to a firearm. What firearm are you referring to?
I don't have anything that there was no firearm. It was just that the clip was there in the back seat, I think.
Okay, so you found a clip but no firearm, is that right?
That's correct.
Okay.
Ms. Tutt, did you also process another vehicle at the scene?
No, it was just the the black Ford Concord.
I'm gonna ask that we correct the record that we indicated the Concord vehicle is a Chrysler, not a Ford. I'm just asking the record.
Right. Yeah, okay.
No, now, I want to correct it now. Just continue to let false evidence. I'm not saying she's testifying falsely, that's an error. We shouldn't have it.
She wrote Ford Concord, and then in her next report, she wrote Chrysler Concord. So it is a Chrysler Concord. I will
take judicial notice that Concord is not made by Ford Motor.
Okay, Ms. Tutt, so you only at the Davidson scene, you only processed the Chrysler Concord, right? Is that correct?
At the scene there, yes.
Okay, so let's move on. Did you at another time process a vehicle when it was towed to a tow yard?
Yes.
And do you recall when that was?
That was the same vehicle, the Ford No.
Chrysler Concord?
It was a Chrysler Concord 4-door.
Okay. Do you recall what color it was?
It was blue.
Okay. I want you to look at your evidence technician report, and you're testifying it was blue, but at some other point, did you write that it was black?
Apparently it was two vehicles that I processed there at the tow yard, a black Ford, a Chrysler Concord, and a Chevrolet Caprice Classic blue in color.
Okay. So the Chrysler Concord, at the time that you wrote this report, was it, do you recall if it was black or blue?
The Chrysler Concord was black.
Okay. So let's talk about the Chrysler Concord. Did you process that vehicle at a tow yard?
Yes.
And what did you find at that time?
Well,
let me ask you this. Did you photograph the vehicle?
I did.
Okay. And did you dust it for prints?
Yes, I did.
Do you recall if you recovered any prints?
I have some latent. Yes, from the Concord. Yes, I lifted a latent print from the right rear panel of the Concord, and I lifted a print from the rear passenger door on the passenger side of the vehicle.
Okay. And did you, I'm sorry, I didn't mean to cut you off.
And then I lifted a print from the front passenger door of the Concorde.
Okay. And then what did you do with that evidence? You recall?
Then that evidence was turned over to the latent print section. I forget.
Okay, thank you. I have no further questions for this witness.
Cross-examine.
Good morning, Ms. Ted. Are you able to hear me okay?
I'm doing okay.
Okay. Ms. Ted, you indicated that you took some photographs in this particular case. Is that correct?
Yes, I did.
Okay. Well, now, when you took these photographs, ma'am, can I ask you, did you take photographs of the finger? Well, explain to the court how latent prints are captured from a motor vehicle for the record.
Okay. A latent print is a print that is not visible to the eye. But when it's dusted, then the print will surface.
Okay.
Once that's done, it's placed on a card and sent to the latent print section of the department.
Once you dust that area, is the print now visible to be able to see?
Yes, it's visible and it's lifted with a tape, a latent print tape.
Did you take pictures of the prints once they were visible?
I don't remember. I don't think so. No, I just dusted the vehicle and lifted the print.
Is that something that you would normally do? Would be to take photographs of the printed area once you determine that they're?
I will take prints of the vehicle. I will dust the vehicle, and then I will lift the print off the vehicle, and then it's sent, like I said, to the latent print section. I don't recall taking photographs of the print.
Were you asked to do so?
No, I was not.
Did you take any photographs of the magazine that you discovered?
If I could recall, I took I took photographs of everything that was in that vehicle and sent to Central Photo. Photographs were sent to Central Photo.
Okay, can you explain to the court or articulate where the magazine was that you indicated that you found?
If I can remember, it was in the you're talking about the black Concorde?
Yes, ma'am.
It was lying on the rear seat. I'm sorry, it was on the floor behind the driver's seat. No, it was on the floor front of the passenger seat was the clip.
The front of the vehicle on the floor of the passenger area, is that correct?
That's correct.
Thank you, nothing further.
Thank you, Ms. Tut. Good to see you again. You take care of yourself.
All right. Thank you. I'm not really sure who I'm talking to, but okay.
It's me. You can't see me? It's Judge King.
No, I don't see you. I just see. No, I don't,
Okay.
But it's good talking to you.
All right.
Bye.
people call Stephanie Sparks, who's on Zoom.
Okay, bringing Ms. Sparks out the way. Ms. Sparks?
Yes, sir.
Hey, I can't see you right now. There you go. Please tell us your name and spell it for us.
Stephanie Sparks, STEPHANIE. Sparks, SPARKS.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. Maybe begin when you're ready.
Ms. Sparks, can you hear me okay? This is Brian Johnson.
Yes, sir, I can hear you.
Okay, good. Where do you currently work?
Los Angeles County Sheriff's Department.
Okay, back on June 28th of 2004, where were you working? June of 2004.
Detroit Police Evidence Tech Unit.
Okay, how long did you work there?
A total of 8 years, I think.
Okay, and on June 30th, 2004, did you find yourself at Gene's Towing at 7900 Dix?
Correct.
Okay, and do you recall what you did at Gene's Towing on that day?
Process the vehicle.
You recall what kind of vehicle?
I have to refer to my report.
Yeah, refer to your
Is that
report.
okay?
And refer to your report and then let me know when you're sufficiently refreshed.
Okay, I am ready.
Okay, what kind of vehicle?
It was a black Chrysler Concorde 4-door with a temp sticker.
Okay.
You want
And
the
when
VIN
you
number?
no, that's okay. And when you processed it, what did you process it for?
I need to refer to my report again.
Okay.
Okay, I'm ready.
Okay, go ahead.
I was instructed to recover a tan colored T-shirt from the vehicle and put it on evidence.
Okay, did you indeed recover a tan colored T-shirt?
I did.
And where was it found? You recall?
I am referring to my report again. Okay, I'm ready.
Where did you find the T-shirt?
I found the T-shirt from the floor in the front of the driver's seat.
Okay.
Do
you recall if there was anything on the T-shirt?
I do. There was suspected blood on the T-shirt.
Okay. I have no, and then you said you turned it over to evidence?
Correct.
I have no further questions, Ms. Wins.
Cross-examine.
Good morning, man.
Good morning.
Ma'am, you indicated that the T-shirt that you recovered was on the floor in the vehicle of the Concorde. Is that correct?
That is correct.
Okay. Have you had an opportunity to look at the crime scene photos in relationship to this case?
I don't recall looking at the photos.
Okay. Who took the photos, as you know, in this particular case?
I have no idea. All I did was process the car.
Okay. Were you the first person to examine the vehicle or the second?
I don't recall.
Okay. And as far as you know, when you went to examine the vehicle, your notes indicate that the tan T-shirt was on the floor. Is that correct?
Correct.
Isn't it true that the tan T-shirt was actually on the front driver's seat, ma'am?
No, if it was on the front driver's seat, I would have put that in my report. I picked it up from the floor in front of the driver's seat.
So you picked it up and took it out of the vehicle and then placed it on evidence, is that correct?
That's correct.
Course indulgence, Sharon.
I'm sorry, did you ask a question? I didn't hear you.
Give me 1 second, please.
Oh, okay.
Made a code.
Yes, please.
Code stuff. Done. Thank you.
Ma'am, are you able to see my screen?
Yes,
Is this a fair and accurate depiction of the car that you processed?
that car is not at Jean's Toe in this photo.
Okay, I'm just asking you, does this look like the car that you processed?
If it is a black Chrysler Concorde, then yes. I don't know what that car is.
Okay, I'm gonna show you some more pictures of it then to see if you can identify whether or not it's a Concorde. Okay, after looking at all the pictures of the vehicle. Are you able to see my screen now?
Yes,
Okay, does that appear to be a Chrysler symbol to you on the trunk of the vehicle?
I can't see the symbol.
Are you able to, so you're from this vehicle, from this picture, you're not able to tell whether or not this is the vehicle that you processed for Jean's towing?
No.
Okay, I'm gonna go then to the photographs at Jean's towing, see if that helps to refresh your recollection, okay?
Go ahead.
1 second, I'm not trying to confuse you, I'm gonna give you all the opportunity you need.
Okay.
Is this Jean's towing?
It looks like it.
And would you say that this is the vehicle that you processed when you went there on that particular day?
It's possible. It looks like it. From what I can see, it just looks like a black car.
Okay. Does this refresh your recollection as to whether or not the T-shirt that you observed was on the floor or if it was in the driver's seat as I asked you?
In this photo, it looks like there's something in the driver's seat.
So, but it's your testimony that when you observed the tan T-shirt, that it was on the floor, is that correct?
That's correct.
Okay. And you wrote down that it was on the floor, correct?
Yes.
Okay, and you did that because you recognize that it's important to capture where evidence is at the time that you actually observed it, correct?
Correct.
Okay, and you're certain that when you observed the tan T-shirt, it was not in the driver's seat, correct?
Correct.
Thank you, nothing further.
Can you redirect? Thank you, ma'am. You're all set. Appreciate you.
All right, no problem.
People have, one more witness, Detective Patrick Lane.
Have a good day, good you. Have a good day, good you. Good to see you again. Good seeing you. Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please sponsor me. The application has your name already. Thank you, Jim. Great.
Thank you, Ron. Can you please state, spell your name for the record, please?
Patrick Lane, PatrickLane.
And where do you work, sir?
I'm a detective for the Detroit Police Department.
How long have you worked there?
Worked 24 years.
24 years, okay. Back on February 4th, 2022, were you working at the Detroit Police Department?
Yes,
Okay. And on that day, did you go to the Detroit Detention Center?
I did.
And at that time, did you talk to a person named Marcus Freeman?
Yes.
Do you recall his date of birth?
I did.
Do you have your report with you?
Yes, I did.
Yeah, if it'll refresh your recollection, look up when you're done. What's his date of birth?
March 19th, 1979.
Look at your report again.
March 13th, 1979.
Thank you. You went to the DDC and you spoke with a person named, did you speak with a person named Marcus Freeman?
Yes.
Do you see Mr. Freeman in the courtroom?
Yes, see behind the desk.
Okay, can you identify him by the article of clothing he's wearing?
Green shirt, whatever shirt.
May the record reflect that the witnesses identify Mr. Freeman?
So noted.
And why did you, what was your reason to interact with Mr. Freeman?
We have a search warrant for a buckle swab. 610.
Okay, what's a buckle swab?
Where you take a Q-tip, basically a sterile Q-tip, and rub it inside of his mouth. You get a sample of saliva.
Okay, and is that for DNA purposes?
Yes,
Okay. Did you get a buckle swab from Mr. Freeman?
I did.
Okay. And what did you do with that buckle swab?
I placed it on evidence.
Okay. Did you have any other, any further involvement in this case?
No.
No further questions, John?
Carson, Jim.
Warning, Detective Lane.
Warrant.
You indicated that you had a search warrant for Mr. Freeman to get through a buckle swab. Is that correct?
Yes.
How was it that he came to be in custody?
I don't recall.
At the time that he was at the DEC, do you know whether or not there was a warrant for his arrest?
I don't.
So how does an individual get to the DEC?
Right, arrest.
So this is not a type of scenario where you called him and told him to meet you at the DEC because you had a buckle swab, correct?
Correct.
So this is a scenario where the defendant was arrested, taken to the DDC, and then you take him to an interview room, serve him with the search warrant. Then if he doesn't comply, then you take him to the hospital. Is that correct?
That is a way to do it, yes.
And that's,
But I'm not sure if I took him to a room or not.
okay. But nonetheless, you took the buckle swab from Mr. Freeman while he was at the DDC. Is that correct?
That's right.
How soon after was he released from the took the buckle swab?
I have no idea.
So your limited purpose in relationship to this case was just taking the buckle swab. Is that correct?
That's correct.
How long have you worked in homicide?
10 years now.
And you've investigated numerous homicides, is that correct?
Yes.
You ever take ballistic evidence to your house and leave it there? Objection relevance? This has nothing to do with ballistic evidence. It's about a book. I have free reign for cross-examination, but I don't know. Like, you ever take ballistic evidence to your house and leave it there and then leave the house and just abandon the house?
Yeah.
Why not?
No need for that. I have no need for that.
You'd agree that it would damage the integrity of the investigation to leave pertinent evidence behind and just never come back and get it. That'd be fair to say?
Are you talking about personal house?
Yes.
How would it be damaged if it's at my personal house?
Then you leave the home.
Right.
And don't come back ever.
I can't speak on that, 'cause I haven't left my own home.
Better less. Thank you.
Can you give me your? Thank you, sir. You may start. You have witnesses?
No, Your Honor.
You have witnesses for the defendant?
What we call detective.
Detective who?
Yes.
Who?
We call detective.
Oh. Who sounds like who? Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat. Please. You can begin when you're ready.
Good morning, Detective. When did you become the officer in charge of this particular case?
It was around March. 2022.
Was there ever a point in time during the course of your investigation where well, let me take you back. Were you still with the department in 2019? Have you reviewed all the police reports in relationship to this case?
Yeah.
Okay. Was there a particular point in time where a home on North Lawn became part of this investigation?
Yes.
Okay. And you'd agree that there was evidence in this particular case that's in relationship to this particular case that was left at that home on North Lawn. Is that correct?
Correct.
Who resided at that home?
The officer didn't know.
Okay. So an officer McMillan at one particular time was the officer who directed the evidence text in this particular case, correct?
That I'm not.
Okay. I'm gonna ask you to take a look at the evidence text before you see it as a question to recollection. Approach, this is a touch screen. Let's just scroll the evidence text report. May I just see if that was addressing it? It was Officer McMillan that sent Ms. Bell and touch to Gene Towing to do the initial processing of the vehicle. Is that correct?
Yes, that report says he's the officer.
Okay. And as the officer in charge, you would take possession of evidence. Is that correct?
It depends. Sometimes, yes.
Okay. Well, let me ask you this, right? Isn't it true that at some particular point in time, you became aware that Officer McMillan, who was the former officer in charge of this case, took ballistic evidence to his home, correct?
Correct.
And then he left it there for a number of years. Is that correct?
I don't know how long they took, but I read reports that say, yeah, home there.
Can you speak into the microphone, please?
It was a report, that states that he, had evidence in his home that he previously lived.
Okay. And Officer McMillan left the department in 2012. Is that correct?
I have no idea who he is.
Okay. Well, you'd agree that this evidence was recovered in 2019. Would that be fair to say?
Yes, sir.
Okay. And you'd agree to take ballistic or any forensic evidence and abandon it at the property would not be proper at all, correct?
It's not police procedure.
Thank you. Nothing further.
Cross.
Yes. Did you write an investigator's report in this case?
Yes,
And you have it with you up there?
I did not.
No, okay. Do you recall the adverse witness run? Do you recall, can you tell me what the report number, the original report number is?
Yes.
What is it?
It's 0406280449.
No further questions?
Anything else from the redirect?
No.
Thank you, sir. You may step down. Anything else from the defendant?
No, the people, the defense arrest.
Your Honor, the people actually have some lab reports they'd like to place in that.
The people arrested her.
I guess it went over my head. I wasn't thinking I still have some evidence.
I don't think he officially said he arrested. I asked if he had any witnesses. He said no.
And then you went right into defense, and
Yeah.
I was thinking about.
Okay.
So under 766.11B, people have a number of lab reports they like to place into evidence. These are lab reports prepared by the Michigan Department of Michigan State Police. The first one is report number MD 21-1109, record number 1, and it is it talks about the 7.62 fire cartridge cases found at the scenes, cartridge cases found at the Tuller scene, and then the fire casings found inside the car. And it says that they are identified as having been fired from the same firearm. People seek to admit that as People's Exhibit 2. Where's this first? Okay. This is ND 21 Lab Report 1109, record number 6. And this is performed by Kathleen Gill, forensic scientist. People seek to admit this as People's Exhibit 3, and it states that this person came into in possession of a magazine that indicated the possible presence of blood under agency number 0462804449. People would seek to admit that in evidence. People's Exhibit 3.
You didn't judge it.
It's the court's discretion.
Admit it.
ND 21-1109, record number 7, performed by, this is a Michigan State report, lab report performed by Jessica Drager, DRAGER, and this is record number 7, and people seek to admit it under People's Exhibit 4, and it is a magazine stain swab and a Marcus Freeman buffalo swab previously analyzed and reported. And it says that based on the DNA typing results obtained from the magazine stain swab, is approximately 240 quintillion times more likely it originated from Marcus Freeman than if it originated from an unrelated unknown contributor. People would seek to admit that as People's Exhibit number 4. This is a request for a latent print search by the Detroit Police Department. This is the results of an examination. People seek to admit this as People's Exhibit 5. It is performed by Brent Scutcheon, latent print examiner, and it says that APIS candidate Marcus Freeman, black male, 10/7/1967. Either way, identified Marcus Freeman as above listed automobile and evidence tag 062713004, right rear panel, figure number 2 and number 3. And then there are unidentified latent print impressions left from the above listed automobile. People seek to admit that under People's Exhibit 5.
So there's no opposition as it relates to the fingerprint scans. One, that's not allowed, right? So, and then 2, in terms of the identifiable factors for Mr. Freeman, he's not born in the 1960s. So I'm not sure how we're supposed to just gloss over that fact. So even if the court determines that it's a lab report, I really don't, I'm not going to get too much pushback about that. It's just most of the pushback I will be is that if we're supposed to take the document face value, him indicating that the document indicated this is a Marcus Freeman 10 years younger, which probably happened. So that's the truth.
I think that gets to weight on this board. I think it gets under 766.11B. It's a report other than a law enforcement report that was made or kept in the ordinary course of business. And that's what this is. It's a latent print examination report. You said other than a law enforcement report. Other than a law enforcement report that is made, yeah.
This is a law enforcement report. It says Detroit Police Department on the document.
Okay, so I would go under 7 subsection D then. Except for the police investigative report, a report prepared by a law enforcement officer or other public agency. Reports permitted under this subdivision include, but are not limited to, a report of the findings of a technician of the Division of the Department of State Police concerned with forensic science, a lab report, a medical report, arson investigative report, an autopsy report, but it says are not limited to. Brent Scutcheon is not a police officer, he's a latent print examiner. Just because it falls under the auspices of the Detroit Police Department is no different than if somebody is working as a forensic scientist for MSP. They're not sworn police officers. This is not a law enforcement.
How do I know that? Just because he says it, the document doesn't indicate that he doesn't work for the Detroit Police Department.
You know, he does work for the Detroit Police Department. He's not a police officer.
How do I know that?
What does he list his title?
Latent print examiner. Not sergeant so-and-so, just as latent print examiner. And no different than Jessica Drager listing herself as a forensic scientist.
But that's different, just because that's elaborate. That's why I'm not objecting to this, because it isn't Detroit Police Department. The document was meant to be, it's a Detroit Police Department report, which is what council cited pursuant to the statute, is not appropriate.
There's all kinds of issues with the report, the identification of the defendant, first being at the hospital, we're talking about the same person, got his date of birth wrong. But I think it goes to what weight the court should attribute these documents, not as the objection will be overruled.
Thank you, Your Honor. The final one will be Exhibit 6, ND 21-1109, record number 5. This is a lab report performed again by Jessica Drager. I've got t-shirt stain cutting, sweatshirt stain cutting, and a contributor, buccal swab already analyzed and reported. And it says that based on the DNA typing results obtained from the t-shirt stain cutting, is approximately 166 trillion times more likely it originated from Marcus Freeman and one unrelated unknown contributor, and then originated from 2 unrelated unknown contributors. People would seek to admit that under People's Exhibit 6.
Any objection?
No.
Admit.
At this time, the people would seek to bind over on all counts except count 3, because we didn't have any testimony of Scott Robbins. And if the court would like to hear argument, we want to give its argument now or defer.
Okay, Mr. True.
Yes, thank you. So Judge, what? I think that cold cases are always tough. But nonetheless, because it's a cold case or because it happened 19 years ago, it doesn't change the burden of proof. And I think that witness testimony matters, right? And what you have is you don't have a single person that can place Mr. Freeman with a gun in his hand or a single person that can identify that he was a driver. So in a drive-by shooting setting, in order to attribute liability to him for a death or an injury that was sustained to anyone present, the government would have to establish that he either drove the vehicle, that he either fired a weapon, or that he assisted someone in firing a weapon. And the court doesn't have any testimony of that on this record. And I think what's even more telling is that this is what they've come up with after 19 years. Never mind the fact that the original officer in charge of this case, in my mind, completely sabotaged any fair efforts for us to adjudicate this matter fairly. I mean, you're talking about an individual who takes forensic evidence to his house, and it's recovered by the Detroit Police Department 15 years after the incident. We have no way of knowing how long it's been there. We have no way of knowing how it got there, why it was there. All we know is that it was there. In fact, we don't even have any photographs specifically as to what was recovered. And then on top of that, we bring in 2 evidence techs, one of whom who testifies on the second day, and she's the second individual to process the car, even though she doesn't remember that. And she says, when I get to the tow yard, the t-shirt that the government is relying on, I presume to attach Mr. Freeman to the vehicle, is to be able to say that he's one of many contributors, because the report says multiple contributors, to that particular shirt. And she says it's on the floor. And then the court has an opportunity to see the pictures. I try to refresh her recollection. He says, isn't it true that these pictures are on the driver's seat? She says, no, it wasn't. It was never there. So then it begs the question, who put it there, right? So if we know that there's at least one officer in charge who was willing to violate all protocols as it relates to evidentiary integrity, is it really far-fetched that a piece of evidence that wasn't originally processed, that's supposed to have blood on it? So the original evidence tag, Ms. Tutt, did actually essentially believe that she was incompetent, that she did not notate or take any type of relevance to seeing a bloody t-shirt or when she's there to process a vehicle for shooting. And then another evidence tech comes back the next day and says it's in a not completely different area, but a different area of the vehicle. So somebody had to put it there. based upon what the photographs reflect. The government asked you to just ignore all that and say, well, Judge, we just want you to gloss over this, find that it's a question of fact. Mr. Freeman can be remanded, he could just sit in jail until sometime next year, and then we can hash this out with a jury. That's just not how our process should work, Judge. We're supposed to be able to have witnesses that can definitively say, Marcus Freeman did this, and this is why he's in a green jumpsuit in that particular chair. We're getting nothing of the sort. They've got no identification. They've got no one that can testify. For example, Judge, who is the vehicle registered to? How do we know that the vehicle wasn't stolen from Mr. Freeman? We don't know any of these things, right? But this is what happens when you wait 20 years to bring a case forward, and this is all you got. And my argument to the court is I want to be as succinct as possible. Aside from the evidentiary woes, on the record is devoid of what Mr. Freeman actually did to participate in the killing. You can't just say, at a minimum, the forensic evidence, if the court chooses to give it appropriate weight, would establish that he was merely that he might have been present in the vehicle. I don't know how you establish that he was present in the vehicle at the time of the shooting, since no witness described him or gave any description that's on point. But the government has to be able to combat it. They're offering nothing to be able to do so. For those reasons, I'm asking the court to dismiss this one. Thank you. Mr. Johnson.
Hey, Your Honor. So we have a number of pieces of evidence that place Mr. Freeman in the vehicle. We have, of course, the T-shirt. The T-shirt came back with his DNA. It's 160 sextillion or whatever it was. The T-shirt, has Mr. Freeman's DNA on it. We have the magazine, which has blood on it. We have Mr. Freeman at the hospital, at Henry Ford Hospital, where he says he was walking on West Davison, where he just was shot in the hand. And he, which Davison is close to Tulsa. And we have the magazine that shows that his blood was on the magazine, that was his DNA. So we have, and then we also have latent prints. Now, as far as the prints go, I submit that it was a mistake on the part of Mr. Scutcheon, because what are the odds that a Marcus Freeman born October 7th, 1967 has the same latent prints as a Marcus Freeman born 3/13/1979? I mean, it's a mistake. That's all it was. So we have his fingerprints. We have his DNA in the car. This is not a merely present situation. Merely present, the jury instruction says, even if the defendant knew the alleged crime was planned or being committed, the mere fact that he was present when it was committed is not enough to prove that he or she assisted in committing it. But the fact that his blood was on the magazine shows that he touched the magazine. The fact that his blood was on the T-shirt shows that he was in the car at the time, and obviously his fingerprints were there at the time. As far as the fact that Miss Tutt or Miss Sparks didn't remember, she's saying that the T-shirt was found in the driver's seat. This happened 19 years ago. She could have been mistaken. It could have been moved before they photographed it. There's all these things, but the main thing is that his DNA was found in the car. And this was, again, a long time ago, and memories get kind of fuzzy. Mr. Wilson testified that there were at least two people. Mr. Clements tried to impeach him with, there might have been three people in the car, but we know there were at least two people in the car. One of them had a 9mm, and he was shot with 7.62 rounds, which is consistent with the rounds that were found in the vehicle that Mr. Freeman was in. And the fact that the rounds either came from, at least, at a very minimum, the driver's side, the driver's seat, or the driver's side passenger seat, or I'm sorry, the passenger seat in front, which is where Mr. Freeman his T-shirt was found, which we could lead to assume that he was at least probably in the front seat at the time. So, this is a cold case. Yes, absolutely. This is a case where memories have gotten a little foggy, but the science doesn't lie. And the fact that Mr. Freeman was in the vehicle, the fact that he had touched the magazine And the fact that he just told police that he was walking down the street and got shot shows that he knows more than he actually does, because nobody just walks down the street and gets shot. He was transported there by an unknown person. And so for all those reasons, I ask that you bind over on this case. Thank you.
May I see the reports, please?
Yes, Your Honor.
Okay, the court has had an opportunity to review the lab reports and the DNA evidence submitted by the people. This was a trial due to the comedy of errors involving this case. This court had no problem in finding the defendant not guilty beyond a reasonable doubt. The standard of proof here is different. The proof here is probable cause standards. So why a police officer would take evidence to his home and abandon that evidence and not be recovered for years? I haven't heard that story until today. But it's beyond me. I find that incredible that an officer would do that and potentially taint that evidence. But that's not the only evidence that I'm dealing with here that is submitted by the people. And it just been that particular evidence, then this court could reasonably conclude that that evidence is tainted and is totally unreliable. However, in addition to that, we have a T-shirt that was found in the vehicle that allegedly has the defendant's DNA. According to the person who did the DNA typing, we're fairly certain that it is the defendant's DNA that was found on that shirt. Whether that shirt was found before or whether it was found on the scene as the defendant along with some other contributors. In addition to that, magazine that was found allegedly has the defendant's DNA on it as well. So one thing we know, based on those two pieces of evidence, is that the defendant was inside the vehicle. Their presence is a defense. But DNA being found on the cartridge is pretty damning evidence that the defendant was more than merely present. Someone reasonably conclude that the defendant aided and abetted at a very, very minimum in the commission of these shootings. By his DNA being found on the cartridge, as well as the shirt being found in the vehicle, and him being at the hospital with a gunshot wound himself. I don't know how he sustained that gunshot wound. Quite possibly a rational trier of fact could find that, as he said, he was walking down the street and was shot. Unlike Mr. Johnson, I have heard of that situation. In fact, someone very close to this court died as a result of that. An officer of this court was walking down the street and was hit by a stray bullet and was killed. In fact, that was my first husband. That happened. After a block of the park, rational trier of fact could find that did happen. Rational trier of fact could find that the story is BS, and that because he was in this vehicle, engaged in this behavior, quite possibly may have either shot himself or someone else in the vehicle shooting accidentally shot him. I don't know what the situation is, but a rational trier of fact could find that he was there and that he was aiding and abetting the commission of these crimes as they unfold. As such, the court is satisfied that people met their burden of probable cause as it relates to the charges contained in the complaint. The court finds that the charges were committed in the city. The court finds probable cause that this was committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date time of July 20th, 2023 at 9:00 a.m.
Judge, may I address mine? Okay. Now, the court, and I agree with the court as relates, and in fact, my perspective is, obviously I disagree. I think the court should dismiss the case, but nonetheless, right? I do agree with the definitive statement that this is the case that the government intends to present at trial, right? In order for a defendant to be remanded, guilt should be evident or the presumption of guilt must be great. So in this particular case, it's littered with reasonable doubt, just based upon the actions of the police alone and the inconsistency of the testimony. What I think is telling and unfortunate is that Mr. Robinson, the government doesn't present Mr. Robinson as a complainant in this particular case, but as an officer of the court, he definitively is on body cam telling the investigator from the Michigan State Police, there were 4 people in the vehicle and all of them had on masks. So Mr. Wilson comes into court and says, no, there were 2 people and doesn't say anything about masks. So you have that inconsistency there. You have the fact that judge, and I would be willing to say this, if you as an officer in charge are willing to take evidence and essentially destroy it and withhold it, it's not beyond you that you would plan it. So you're looking at a case where there's no pictures of these photographs. The shirt that supposedly has my client's DNA on it, which is, and I appreciate the brother counsel tried to clean it up by saying she might have remembered things, but she wrote it in a report and it was on the floor. So that's why I was giving her an opportunity to say, no, I may have been mistaken. And the shirt is clearly in the driver's seat. We would submit to the court because that's evidence of that suggests evidence manipulation. And it doesn't take a wildly imaginative person to conclude it. I'm not asking for a personal bond, judge, but this is a 19-year-old murder case where the testimony is, you have no identification of anyone that can say that Mr. Freeman did a specific thing to contribute to this killing. I'm asking the court to, I'm citing People versus Reginald Davis, which of course was my case. Reginald Davis was a violent at 4. with Judge Green, looked specifically at the likelihood of conviction and came to the same conclusion that this court came to when you evaluate the facts, I would have no problem finding the defendant not guilty. If that's the case, then he's required to be admitted to bail. I'm asking the court to set bond, given the weakness of the case, at 100,000, 10%.
Mr. Johnson.
Your Honor, the Clements stated as far as what the other person said, that wasn't Mr. Robinson, that was a different person. But as far as bond goes, I mean, is the court binding over all charges except for the Scott Robinson?
Yes.
Just to make sure. You know, this is a first degree murder case. Just because it happened 19 years ago doesn't mean that it's any less serious. And I think if the court, the circuit court wants to order the issue of court of readdress bond, then I would be happy with that. But at this point, he's been bound over on first degree murder, drive-by shooting case, and that's the bond remain the same.
I would just indicate that Reginald Davis is a first degree murder case and it's a drive-by shooting. And the case that the people had in that case was stronger than this because they actually had a witness that said that Mr. Davis committed the crime. The government doesn't have that. And notice that Mr. Johnson, because he's a good lawyer and a fair-minded person, he's not saying that they have a strong case. He's just saying he's charged with first degree murder. He's been bound over. He should be remanded. And I appreciate that that was the standard method of operation before the Court of Appeals in a published case decided People versus Davis. You cannot remand people anymore just based on the charge. It's got to be based upon the strength and weaknesses of the case. And this is an extremely weak case. It's a case that's so weak that I'd be inclined to do a bench trial almost in front of any judge that's in that building on 1441 St. Antoine, regardless of how I personally feel about whether or not they're pro-prosecution or pro-defense based on my experience. When you look at the texture of the evidence, it's just not there. And that's why the case lay dormant for 20 years. I don't know why they drew it up, but they better have a lot more than what they have now. My client shouldn't have to sit in jail until 2024 when we have a trial, because that's the soonest that I would be available.
Well, that's just it. They don't have to put their entire case on the preliminary examination. It's just that it's preliminary. And I would expect, and I don't know, and I don't mean to give the prosecution a roadmap, but if I'm a prosecutor in this case, I'm going to do some things like get the defendant's hospital records to show that it was in fact the defendant that was at the hospital at the time and not some other person. I'm going to, I mean, there's a number of things. There's a lot of work that has to be done in this case. I'm not going to give prosecution a roadmap because that's not my function or my purpose. But talking about the strength and the weaknesses of this case, one of the things that's undeniable strength about this case is the DNA evidence. And you'll have your work cut out for you in trying to overcome that. In that, why is he in the vehicle? Why is his blood allegedly found on the cartridge to a gun? And that there are two different shooters in this vehicle. If he was innocent bystander or was merely present, why didn't he indicate that at the time? Now, I know that that's not the way things go, particularly in the streets. They're not going to come forward and say, or be a snitch, so to speak. But your regular layperson are going to have these questions. If you're just merely present, why didn't you say so? Why didn't you say so then? That you had nothing to do with it, you didn't have anything to do with this, you didn't know this was going to happen. So as much as there are a lot of errors that were made in this case, particularly in behalf of the police in mishandling the evidence, some of the evidence, there's other portions of this evidence that are very strong. It's as such, I'm not going to touch the bond at this time because I'm not saying that people's weaknesses in the case that they presented at the preliminary examination are also imminent at the trial. I don't know that to be the case because there is some work to be done, but I don't think it can't be overcome. on either of them. So the court is going to continue to remand. I will refer to pretrial services. I just gave it back to the question.
Give a copy of the report or anything.
Oh, did they do a dismissal?
Maybe Mr. Perkins. Maybe Mr. Perkins.
What's that?
Can you catch Mr.
Maybe a dismissal for count three.
Clemens?
I'll do it.
He can do it. He was co-counsel. That's it for today, folks. Hope to see you tomorrow, same bat station, same bat time. Peace. Dismissal.